This tutorial will cover the Privacy Act 1988 and how it relates to real estate.
Privacy Act 1988. This is another huge piece of legislation that affects us in many different areas in real estate. It is also a Commonwealth legislation, so applicable to all businesses in Australia, and it regulates the handling of personal information about individuals. So I'm going to give you a few examples here on how it may affect you in your day-to-day business. So let's look at tenancy applications to begin with. If you've ever rented a property before and applied for a rental, the information that you're putting on that tenancy application, you have your full name, you have your date of birth, you have your income, you have your work, you have your family members and friends as references. You may also have photocopied 100 points of ID. You may also have bank statements or other financial documents to prove that you can afford the rent. So all of this information is obviously very sensitive, so it's important that the agency handles it in a specific way. And the main rules is that the information obviously should not be made available to a third party, and it must be stored securely in an agency, so not for everybody to get their hands on and see. So you should have password protected computers, you should have lockable cabinets for all of your sensitive information, and if the tenancy application is not approved, that tenancy application should also be destroyed and not held in the office. The use of personal information, so the Privacy Act also specifies what we can or cannot do with information that we collect. Now, for example, with tenancy applications, there'll normally be a privacy disclaimer that the person signs that will allow us to call the people on the references and collect personal information about that person. So it's a privacy release, sorry, is probably a better word for it. However, let's look at the information that you collect at open homes. So if you've ever been to an open for inspection, you most likely might have had a couple of different scenarios happen where the salesperson will either tell you to write your name down on an open home register, which may be sitting on the kitchen bench, or they may ask for your details and be writing that down themselves. Now, the correct way to do it is that the salesperson or the property manager should be writing down your information and not leaving it on the kitchen bench. So as an example for you, there was a case where a buyer walked into a property that was going to be sold at auction, and he really loved the house and didn't want any competition. So he took his phone, and the open home register was sitting on the kitchen bench. He took a photo of that open home register, which had everybody's names, contact phone numbers and email addresses, and started calling those people to try and intimidate them away from purchasing that property. So it's really important. Most people would never have think to do that. However, you just don't know. So the information that you collect shouldn't be made available for anybody to see that comes to that open for inspection. So best practice is to have a privacy statement up somewhere at your open homes, which tells them why you're collecting the information, and that is to ensure the security of the home and the possessions in the home for the person people living there, and also to enable us to contact that person after to gather feedback for the owner. That's why we collect the information. What we're going to do with it is contact you after to find feedback for the owner, and you cannot use that information for a secondary purpose. So what that means is, unless you've specifically asked the person when they come to the inspection, you cannot take your open home register back to the office, hand it to the administration person and get them to add them to the database and start sending them information the next week about other open for inspections. The main purpose that you've collected the information for is to gather feedback for your owner. So a secondary purpose would be then to start marketing to those people about other properties, which is not allowed. So if you want to do that, you have to get permission from those people to contact them. So when you're writing the name down, you can say, if this property was not suitable for you, would you mind if we send you further information about other properties that may become available? If they say yes, then you can use it. So the Privacy Act is all about gaining permission from people to contact them and then to remain in contact as well. So if you are going to email people, or you're going to send text messages, or however it is that you're going to market, you also need to provide them with an opt-out option. So for example, on emails, you'll have an unsubscribe option, or for text messages, you'll have an option which is for them to reply stop if they don't want to receive further information from you. So there are other areas that the Privacy Act will affect us as well, but those are the key areas, which is your tenancy applications and the way that you collect and use information from your clients and customers.